Good morning, good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Tuesday, May 13th, 2025 at 1:24 in the afternoon. So we're here this afternoon to go through a couple of few bills that we have on the wall. H 160, which is an act relating to creating a right to repair for medical devices. So we have our legislative counsel with us, Rick Stagel. Rick, thank you for coming in. Forward to you walking us through the language.
Yes, good afternoon. Rick Sagel, Office of Legislative Counsel. So start with 160. Okay. So H 160, these two bills, one is a right to repair medical devices, medical equipment. The other one is a more general right to repair. The right to repair laws are pretty new. Generally speaking, a handful of states have passed them. And for the most part, they tend to be about digital devices. New York passed a law a few years ago that was for digital device equipment. And there's usually some exceptions. And the exceptions usually include medical devices. Not one state, as of my research, has passed a law that would give the right to repair medical devices. And I'm sure there's reasons why, political reasons otherwise. But just so you all know, this would be first of its kind to repair medical devices. So good to go? Okay. So this would be we don't have any right to repair statutes on our books. This would be a new chapter in Title IX, 106, right to repair. I created a new chapter because I figured there are several of these bills that come up every session. Last year, we had a right to repair ag equipment that got to the House in 2023, went to the Senate in 2024. They passed it with amendments and it installed out in the House. So that would have been the first specific to agriculture equipment, but it didn't get passed. So this would be a first of its kind, a right to repair medical devices. So we define what an authorized repair provider is. It's basically an individual or business that has an arrangement with the OEM, which I'm going to use to save time, original equipment manufacturer, under which the OEM grants to the individual or business a license to use a trade name, service mark, or other proprietary identifier for the purposes of offering the services of diagnosis, maintenance, or repair of medical equipment under the name of the OEM or other arrangement with the OEM to offer such services on behalf of the OEM. You've probably dealt with one of these people before. They work on behalf of the OEM to repair equipment made by the OEM. They're authorized through some kind of contract with the OEM to make those repairs. An OEM that offers the services of diagnosis, maintenance, repair of its own medical equipment shall be considered an authorized repair provider, as we use that term in this bill. Documentation is any manual, diagram, reporting output, service code description, diagram, code, password, or other guidance or information, whether in electronic or tangible format, used to perform the services of diagnosis, maintenance, or repair of medical equipment. Fair and reasonable terms means making available parts, tools, or documentation as follows. With respect to documentation required for repair, that it's provided to the OEM at no charge, except when it's requested in physical form, a charge may be included for the reasonable actual cost of preparing and sending the copy. For tools that are made available by the OEM at no charge and without requiring authorization or internet access for use or operation of the tool, or imposing impediments to access or use of the tool to diagnose, maintain, or repair and enable full functionality of medical equipment. Except when it's in physical form, again, you can charge a reasonable actual cost for sending the tool. For parts, either directly or indirectly through an authorized repair provider, to independent repair providers and healthcare facilities at reasonable costs and terms that are equivalent to the most favorable costs and terms under which an OEM offers the part to an authorized repair provider. And We're still talking about parts here. Account for any discount, rebate, convenient and timely means of delivery, means of enabling fully restored and updated functionality, rights of use, or other incentive or preference the OEM offers to an authorized repair provider, or any additional cost burden or impediment the OEM imposes on an independent repair provider or healthcare facility. Are not conditioned on or imposing a substantial obligation or restriction that is not reasonably necessary for enabling the independent repair provider or healthcare facility to engage in the diagnosis, maintenance, or repair of medical equipment made by or on behalf of the OEM, and are not conditioned on an arrangement or described in 1A, which is the authorized repair provider definition. Healthcare facility means all persons or institutions, including mobile facilities, whether public, private, profit or not profit, that are offer diagnosis, treatment, inpatient or ambulatory care to two or more unrelated persons, and the buildings in which those services are offered. This shall not apply to any facility operated by religious groups relying solely on spiritual means through prayer or healing, but includes all institutions, including 18 BSA 9432.8. A cross-reference there you can look at, except health maintenance organizations. Independent repair provider means a person operating in the state who does not have an arrangement with an OEM, as described in the authorized repair provider section, and who is engaged in the diagnosis, service, maintenance, or repair of medical equipment. Medical equipment or equipment means any powered device approved by the US FDA that is used in the treatment, monitoring, or diagnosis of a patient and includes assistive, adaptive, and rehabilitative devices. OEM means a business engaged in the business of selling, leasing, or otherwise supplying new medical equipment manufactured by or on behalf of itself. Part means any replacement part, either used or new, made available by the OEM for purposes of effecting the services of maintenance or repair of medical equipment manufactured by or on behalf of, sold, or otherwise supplied by the OEM. Tools means any software program, service key, hardware implement, or other apparatus used for diagnosis, maintenance, or repair of medical equipment, including software or other mechanisms that provision, program, or repair a new part, facilitate access to the equipment's repair and diagnostic functions, calibrate functionality, or repair any other function required to bring the product back to fully functional condition, including updates. And then trade secret is cross-referenced with the federal definition. Okay, questions about the definitions?
The independent repair provider, the section 1A, who is engaged in the diagnosis, service, and maintenance or repair of medical equipment. My concern is I don't want some hack job. My uncle, hey, he knows some electronics. I'm going to have him repair it. Does this provide some sort of, I don't know, guideline or provision to ensure that this person is actually qualified to make this repair?
Qualified, not necessarily, but they are engaged in the diagnosis, service, maintenance, or repair of medical equipment. There's some gray area there, right? If it's some guy that does this as a hobby, is that person engaged in that industry? Maybe it would be kind of a determination as to whether this person qualifies as an independent repair provider.
Yeah, I mean, that'd be an important thing for me because, I mean, it's one thing when I'm repairing an iPhone, but we're talking about medical equipment, and the last thing we need is someone to make a faulty repair and someone dies.
Sure. We could shore that up or further define it.
Can we go back to the healthcare facility? I feel like the term shall not apply to any facility operated by religious groups relying solely on spiritual means through prayer and healing. Besides the fact that I'm not familiar with those type of organizations. But why is that in there?
Talk to the sponsor about that. That's something that was included. So it's probably meant to exclude what not many people would consider a healthcare facility. But again, probably a question for the sponsor to talk about.
As a legal person, what is that? Like, is that like Scientology?
I mean, we're reading the same words here. Any facility operated by a religious group relying solely on spiritual means through prayer or healing. I must assume these places exist. I can't tell you what they're called. I can't tell you where they're located, but I think it's meant to not include places like that.
I don't know if it applies for here because you would think an organization like that probably isn't gonna have any.
I know.
Need to be repaired.
Unless it was Seventh Day or Scientology. I mean, they have, I think that's.
They have things here.
Don't they? Aren't
The
they?
definition for what a healthcare facility is, it's not a definition for a place that may or may not have something, right? So in the bill, it's talking about a healthcare facility, it's referring to certain places. So this, don't take the context out of the bill just for a moment, step back. Think about anytime we talk about healthcare facility in the bill, we're referring to these things and not these things, and then go back.
Right, and I get
And I think that definition is because there are healthcare facilities that are religious and that are religious based.
Well, yeah, but they're not providing, they're providing more of a through prayer,
Right,
they're using
they're not using actual
equipment.
Just offer. I suspect you could know better than I, but I wouldn't be surprised if that's a fairly standard clause that's included in a lot of definitions around healthcare facilities. Whether it's appropriate fit here, I really don't know, but it looks like something that seems familiar, just as a stock kind of. We're not gonna impinge on your First Amendment rights.
okay. If it's a standard thing out, that's fine.
I would like some clarification on the last clause, except health maintenance organizations. Is that referring to health maintenance organizations that are run by groups relying solely on spiritual means through prayer?
I'll go back to you on that one. I don't know. Yeah. So,
There's a chapter there we could probably look at.
Yeah, but that may be hospitals that are run by
Yeah.
a certain denomination.
Yeah.
But they are legit hospitals. They're
Right.
physical hospitals. Yeah.
I don't mean to be odd about it. It seems odd in itself. Like I
Yeah, but I don't think you want to pull in religious groups that are operating through prayer healing. Whatever they have in their building as being medical equipment that has a right to repair, right?
Okay.
We'll learn more about it.
This might be we need to learn more about it, but I'm curious about, especially with the independent repair provider, if there's any conversation about like voided warranties or liability.
I believe that has come up later in the bill. Yep.
Other questions on definitions?
Okay, requirements. 4050 subsection A, general requirements. For medical equipment and parts sold and used in the state, I'm going to come back to that in a second. The OEM of the equipment or parts or an authorized repair provider shall make available to independent repair providers and healthcare facilities on fair and reasonable terms any documentation, parts, and tools required for the diagnosis, maintenance, or repair of medical equipment and parts for medical equipment, inclusive of any updates to the information, and training courses and materials on the operation, inspection, diagnosis, maintenance, and repair of the equipment that the OEM similarly provides to authorized repair providers. So I just want to highlight this. This is pretty important here. This would limit it to parts and equipment that are sold and used. So I'm not sure this is intentional, but it's the way the bill is written, that only medical equipment that are sold and then used in the state would be covered by the law. So if you bought the part in New York and you brought it here, and I'm bringing this up because later in the bill, in the implementation, it says sold or used. So we probably want to address what you want it to do. If you want to require both, it's sold and used in the state, or probably what it was intended to say.
Sold or used.
Yes, just want to bring that up. Okay. Security lock access for medical equipment sold and used in the state that contains an electronic, same thing there, contains an electronic security lock or other security related function, the OEM of the equipment or parts, or an authorized repair provider shall make available to independent repair providers and healthcare facilities on fair and reasonable terms, special documentation, tools, and parts required to access and reset the lock or function when disabled in the course of diagnosis, maintenance, or repair of such equipment. The documentation, tools, and parts may be made available through appropriate secure release systems. Limitations. This subchapter does not require an OEM to divulge a trade secret to an independent repair provider or healthcare facility. The subchapter does not alter the terms of any arrangement, but described in subdivision 40, basically the authorized repair provider and the OEM, including the performance or provision of warranty or recall repair work by an authorized repair provider on behalf of an OEM, pursuant to such arrangement, except that any provision governing such an arrangement that purports to waive, avoid, restrict, or limit the OEM's obligations to comply with the subchapter is void and unenforceable. OEMs and authorized repair providers are not liable for damage caused to any medical equipment by independent repair providers or healthcare facilities that occurs during the course of repair, diagnosis, or maintenance of the equipment. Enforcement. This law would bring in the Vermont Consumer Protection Act, which is that section 2453, the Unfair and Deceptive Act language. And just like in most laws that call in the Consumer Protection Act, the AG has the right to adopt rules and conduct investigations, otherwise enforce the bill. The implementation. The act applies to medical equipment and parts sold or in use in the state on or after the effective date of the act. So again, that's kind of confusing. We probably want to make sure the language is the same. And then the effective date would be July 1st, 2025. Questions?
Next.
Okay. Next, we have 161, which is also right to repair. And you'll see similar language. It's different, but there are some similarities here.
Longer.
It is longer. But when you do the Data Privacy Act, right, and you compare it to this, 10 pages, that's a cakewalk. Okay, H-161. So the previous bill was just limited to medical devices. This is more of a, I'm not going to call it omnibus, but it covers digital equipment and it covers agriculture and forestry equipment. So some of this language is what came from the bill last year that stalled out towards the end, the right to repair ag equipment. That was brought over into this bill, and we added in electronic equipment, the right to repair that kind of equipment, which I mentioned. There are some states that pass that, New York being one, California, Colorado, I believe, Minnesota. A handful of states have done this. But I believe only Colorado has passed ag equipment. I think they're the only one that's passed the right to repair agriculture equipment. Okay, this is, go past the purpose. Again, the purpose is to give independent repair providers and owners the right to repair their agriculture, electronic, and forestry equipment in a safe, secure, reliable, and sustainable manner. This would be called the Vermont Fair Repair Act, also in Chapter 160. So agriculture equipment is defined as a device, part of a device, or an attachment to a device used principally off-road and designed principally for an agricultural purpose, including a tractor, trailer, or combine, implements for tillage, planting, or cultivation, and other equipment principally associated with livestock or crop production, horticulture, or floriculture. authorized repair provider. I assume it's very similar, but I'm going to read it again to the last bill. It's an individual business that has an arrangement with the OEM under which the OEM grants the individual business a license to use a trade name, service mark, or other proprietary identifier for the purposes of offering the services of diagnosis, maintenance, or complete repair of equipment under the name of the OEM or other arrangement with the OEM to offer such services on behalf of the OEM. An OEM that does this on their own is called an authorized repair provider for purposes of the bill. Documentation means any manual, diagram, reporting output, service code description, schematic diagram, security code, password, or other guidance or information used to perform the services of diagnosis, maintenance, repair of agricultural, electronic, or forestry equipment. Embedded software means any programmable software instructions delivered with or loaded onto equipment or part of equipment to allow the equipment or part to operate or communicate with other computer hardware. Embedded software includes all relevant patches and fixes that the manufacturer makes for the purposes of diagnosis, maintenance, or repair. Electronic equipment means digital electronic equipment or a part for such equipment originally manufactured for distribution and sale in the US. That's a pretty broad definition. Forestry equipment means non-divisible equipment, implements, accessories, contrivances, I believe is how you pronounce that, used principally off-road and in harvesting timber or for on-site processing of wood forest products, including equipment used to construct, maintain, or install infrastructure necessary to and associated with a logging operation. Independent repair provider means a person operating in the state, either through a physical business location or through a mobile service that offers on-site repairs in the state, that does not have a authorized repair arrangement, and that is engaged in the services of diagnosis, maintenance, or repair of agricultural, electronic, or forestry equipment. We define medical device here because we exempt medical devices from this bill, which may seem strange, but they're two different bills, right? So this bill, if you pass this one, would specifically exempt the right to repair medical devices. Motor vehicles defined because it also exempts motor vehicles. Most right to repair laws do this. It means any vehicle that is designed for transporting persons or property on the street or highway and is certified by the motor vehicle manufacturer under all applicable federal safety and emission standards and requirements for distribution and sale in the US. Does not include a motorcycle or an RV or manufactured home equipped for habitation. So those would possibly be, they have to be under a different, maybe electronic definition, but those are not specifically exempted from the term motor vehicle. Motor vehicle dealer is a person who in the ordinary course of business is engaged in the business of selling or leasing new motor vehicles to a person pursuant to a franchise agreement and who's engaged in the diagnosis, service, maintenance, or repair of motor vehicles or motor vehicle engines pursuant to such franchise agreement. Motor vehicle manufacturer means a person engaged in the business of manufacturing or assembling new motor vehicles. Original equipment manufacturer means a person who in the ordinary course of business is engaged in the business of selling or leasing new agricultural, electronic, or forestry equipment manufactured by or on behalf of the person. Owner means a person who owns or leases agricultural, electronic, or forestry equipment used in the state. Part means any replacement part, either new or used, made available by an OEM for purposes of effecting the services of maintenance or repair of the equipment manufactured by or on behalf, sold or otherwise supplied by the OEM. Parts pairing means the practice of by the OEM of using software to identify component parts through a unique identifier. Repair means to maintain, diagnose, or fix agricultural, electronic, or forestry equipment, resulting in the equipment being restored to its fully functional condition, including any updates. Repair does not include the ability to download or access the source code of any embedded software or code, unless doing so is required to restore the equipment to its fully functional condition, including any updates. Tools means any software program, hardware implement, or other apparatus used for diagnosis, maintenance, or repair of equipment, including software or other mechanisms that provision, program, or require parts pairing, calibrate functionality, or perform any other function required to bring the product back to fully functional condition, including any updates. Then we have the trade secret cross-reference. Any questions about the definitions? Okay, requirements. Duty to make available parts, tools, and documentation. An OEM shall offer for sale or otherwise make available to an independent repair provider or owner the parts, tools, and documentation that the OEM offers for sale or otherwise makes available to an authorized repair provider. If equipment includes an electronic security lock or other security-related function that must be unlocked, enabled, or disabled to perform diagnosis, maintenance, or repair of the equipment, an OEM shall make available to an independent repair provider or owner any parts, tools, and documentation necessary to unlock or disable the function and to reset the lock function after it is complete. An OEM may satisfy its obligation to make parts, tools, and documentation available to an independent repair provider or owner through an authorized repair provider that consents to sell or make available parts, tools, documentation on behalf of the manufacturer. Okay, subsection B, unreasonable costs or burdens prohibited. Under the terms governing the sale or provision of parts, tools, and documentation, an OEM shall not impose on an independent repair provider or owner an additional cost or burden that is not reasonably necessary within the ordinary course of business, or is designed to be an impediment on the independent repair provider or owner, including a substantial obligation to use or a restriction on the use of the parts, tools, or documentation necessary to diagnose, maintain, or repair the equipment. A condition that the independent repair provider or owner become an authorized repair provider of the OEM. A requirement that a part, tool, or documentation be registered, paired with, or approved by the OEM or an authorized repair provider before the part, tool, or documentation is operational. An additional burden or material change that adversely affects the timeliness or method of delivering parts, tools, or documentation. Application limitations. This chapter does not require an OEM to divulge a trade secret to an independent repair provider or owner. Does not alter the terms of any arrangement described in 4051 2A, which is the authorized repair provider agreement, including the performance or provision of warranty or recall repair work by an authorized repair provider or on behalf of an OEM, except any provision governing such arrangement that purports to waive, avoid, restrict, or limit the OEM's obligations to comply with this chapter is void and unenforceable.
That's the question. Going back to the, a little bit, yeah, doesn't require OEM to divulge a trade secret. Are there disputes, but I mean, I could imagine OEM might saying, geez, this documentation is trade secret, whatever. Are you aware of any, I guess, litigation disputes around that?
My understanding
Probably
is
not, but maybe not, or.
not litigation. My understanding is that's a big sticking point for the
Yeah.
OEMs is they would argue that this makes them divulge that information if they're required by law to provide documentation,
That's what I was.
parts, whatever it is.
Right.
So you're trying to thread a needle here of requiring them to produce this stuff, but also not required to divulge trade secrets, which I don't know if you can do both, I'm sure you'll hear testimony that would
Yeah,
answer that question.
it might be something to look into to, certainly avoid disputes if you could define it a little better.
My question pertains to line 7 on page 7. We use the phrase ordinary course of business,
Mhm.
and it's referring there to an original equipment manufacturer. Does that mean then that it's the same ordinary course of business that's being used in the definition of an original equipment manufacturer? That's on page 5, line 2. We talk about a person who, in the ordinary course of business, is engaged in the business of selling, etc.
Right.
My thought is if those are referring to the same thing, then fine, but I'm also wondering if one might say, well, I'm an original equipment manufacturer in my ordinary course of business. And this is why it's not a, maybe this is a different conversation for later. My question about that is whether we could say the ordinary course of business is providing these repair stuff, is we do that, on your behalf.
Right, I understand. They're different.
They're different. So
The definition meaning is this is, and this is what I think was it Rev Nicholas or Budin was asking earlier about. We don't want, I think it's Rev Nicholas about having a random person fix this medical equipment, right? So if you're an OEM, that's your business, right? You manufacture the stuff. You have a company, you have maybe you're incorporated, whatever it is, right? That's the definition here, line 7 on page 7. You're trying to protect consumers, right? So you're saying that an OEM shall not impose on a independent repair provider or owner an additional cost or burden that is not reasonably necessary within the ordinary course of business. So, if they are providing a part that costs $20 to ship, that's probably a reasonable cost, right? Because in the ordinary course of business, you would deliver this part to the owner or to the shop. Would you charge a $20 processing fee or a surcharge, right?
So page 7, line 7 is referring to that interaction between the OEM and the independent repair.
And
provider.
that cost incurred of doing something, is that an ordinary thing you would incur while sending a part or emailing a diagram, right? I think that's what it's referring to.
Thanks.
I mean, the way I interpret it is, $10,000 for a screwdriver.
That would not be, in my legal opinion. Yeah. Ordinary course of business.
Unless you went to that school.
Yeah, I can't.
And I'm thinking of a scenario of McDonald's and their ice cream machines, which is always broken and they don't. No, it's legitimately like, and one of the reasons why is because they're only allowed certain people are allowed to repair only. And they're really strict on that. So that would be, we might see more ice cream at our McDonald's. Is that what you're telling me? I mean, right? Am I correct?
Franchise agreement notwithstanding.
It depends on who owns the machine, right? Or who's the independent repair provider. Right. So there's probably an owner. I'm not sure McDonald's owns a machine, right? But if they did, then you have franchise agreements too. So it would get complicated.
Okay.
My question on page 7, line 7, regarding the reasonably necessary thing, and you said this is new territory for many states. I'm assuming reasonably necessary would have to be determined by a court. So is there any body of history developed or developing on this definition yet?
So it's all context related, right? So I can't tell you that there's been a lot of litigation on these because there has not been.
Okay.
There's not like a landmark case I can point to that says that this is how we define what this is. So I think it would just be really fact specific. And if you're trying to get a part for your iPhone or whatever you're trying to get fixed, and that part, a new screen, right? The new screen costs $150. I think Apple or Google or whoever makes the phone would have to show you that this is the cost, right, of this part. Yeah. It's just so fact
So
specific.
there are some specific ways that can be quantified, at least,
I think it'd be up to the consumer to say, I don't think this is reasonable. You want to charge me $1,000 for a screwdriver,
Yeah.
whatever. Right. So I think it's meant to govern what you can't cover. You don't know how much a part's going to cost. So you say reasonably necessary to hopefully have the parties come to an agreement about what this thing should cost.
Including automobiles. Because, I mean, I paid $2,000 for tie rods, so that seems a little unreasonable.
Question for another person, but
Okay.
I don't believe any of these recent laws include motor vehicles. I could be wrong. I think now some states have touched on this separately, motor vehicle repair. but
You already have agreements in place.
Oh, actually, just to piggyback on that, are there actually statutes that are governing automobile repair?
They have
I,
kind of like, John Deere has an MMOU with farmers. Their repairs, the right to repair. I believe that the auto dealers, auto manufacturers have some type of an MOU. That's. But we can take more testimony on that when if we start getting into it.
okay, I think I was on B. Yep. Actually, so alter the terms of, and then line 12, a lease of agricultural, electronic, or forestry equipment between an owner and another person. So you can't alter the terms of a lease that you have with some type of equipment and another person. An independent repair provider or owner shall not modify agricultural or forestry equipment to temporarily deactivate safety notification systems, except as necessary to provide diagnosis, maintenance, or repair services, or obtain or use parts, tools, or documentation to evade or violate emissions, copyright, trademark, or patent laws, or to engage in any other illegal activity. Subject to a later subdivision, OEMs and authorized repair providers are not liable for negligent repairs completed by independent repair providers or owners, including negligent repairs that cause damage to equipment that occurs during such repairs, and an inability to use or the reduced functionality of agricultural and electronic forestry equipment resulting from the negligent repair. However, a repair completed by an independent repair provider or owner resulting in damage to equipment or the reduced functionality of equipment that was caused by a defective or faulty part, tool, or documentation provided by the OEM shall not be considered a negligent repair. In the event that federal law preempts part of the activity regulated by this chapter, the chapter shall be construed to regulate the activity not preempted. So if the federal government passes a law, Congress, that says you have the right to repair farm equipment only, right? Then that law would preempt the farm equipment portion of this law. But the electronic equipment and the forestry equipment would not be preempted. If an OEM is a party to a MOU that is related to the right to repair of agricultural, electronic, or forestry equipment, the OEM shall still be obligated to meet the requirements established in this chapter. The chair mentioned that John Deere has MOUs with, I think, the American Farm Bureau. Last I checked, they did. But MOUs are a promise, right? They're not really binding. So this came from the language last year that there was a suggestion that MOUs are good. However, if the MOUs are not effective, then we still want to make sure that the OEMs are held accountable under the bill. Exclusions. This chapter shall not apply to a motor vehicle manufacturer, a product or service of a motor vehicle manufacturer, or a motor vehicle dealer. The chapter shall not require a manufacturer of a medical device to implement a provision in this chapter that is not permitted under the Federal Food, Drug, and Cosmetic Act or any other federal law that supersedes this section. Similar AG enforcement, a violation is a violation of the Vermont Consumer Protection Act. And the AG has the same authority to make rules and enforce the law. C is unique. The AG shall be notified in writing by the OEM not later than 30 days after an MOU expires or has been terminated, withdrawn, or canceled by OEM subject to the chapter. And the effective date would be January 1, 2026. Any questions about this one?
I think the next thing is just to chat a little bit about H205, the non-compete bill. we've been discussing about having letters sent on the franchisor piece, franchisee, to PR, maybe talk to secretary, because PR was suggesting that they might like to have that conversation with OPR as well. But to take a look, I think Helen had pulled up, if there's 12 states, there's some type of regulation, registration on franchisors. And so I think that's the route that we were gonna take this year and come back next year with a plan from DFR OPR on how we could do that. That work for everyone. Sorry. Go ahead.
With the scope, so we're asking them to report back to us kind of thing.
Yeah, take a look at
Yeah.
what the other states doing.
Yeah.
Uh,
Is that limited to franchises or other
well,
areas
so this is for franchisors
only?
only. And the other side of the bill dealt with non-competes for employees, employers.
Right.
And so at that point, I think we've had a conversation with Chris Delia from the Bankers Association and others, that they would be willing to also take a look at this, take a look at that over the summer to see what case law there is in Vermont, and work with others, advocates on the employee side as well. So if they could sit down over the summer
Okay.
and come up with, and not putting anything in statute to create a study committee or anything, sending them a letter asking them if they could do that and come to us.
Yeah, I mean, I like the idea of, franchises are good and important, I think. The employees, I think are pretty, that's good.
I mean, there's just you might have a non-compete. So,
We'll hear about it.
that's we'll take on that, and if anyone would like to work with Rick to on the employee side, and maybe working with Chris Delia and maybe with David Mickenberg, just to understand who we should ask to sit at the table and then, what we're looking for.
I'll do that.
Okay. All right. You heard you.
No, I mean, I
You can
probably
do
don't need
two.
to. Just be someone.
So if
Yeah,
we
I'm
could
interested in
touch- yeah,
non-competes,
Touch base with,
yeah.
with Chris and
Okay.
with David, and sure there's others. If David, you're willing.
Yep.
Okay. And just identify who should sit down and.
Do you want to do that too, Dave? Is that something you were going to handle for?
No, I'm good.
Okay, great. So if you could start that, and then what we'll do is work with Rick to draft a letter, and then we'll bring it back to the committee.
Okay.
I'll have a conversation with Lauren, and then I can sit down, Katie and I can sit down with Rick on the franchisor piece.
Okay.
And then come back and bring language back to the committee on that. And I think that's a good way to tackle it, summer. And I think the last thing, Rick, I just thought we'd take a look at 512. Just. Well, that's Cameron. Is Cameron coming in at 2:30? So we'll wait on, we'll take a break till 2:30 then. Rick will make an appointment with you, sit down. Once I hear from Lauren, and maybe you, Edie and I and Lauren and Aaron could sit down and kind of look at what we'd ask them to take a look at over the summer.
Sure.